got you registered here on behalf of yourself and testifying against House Bill 17.5.
Thank you, Chairman Lee.
Correct?
Yes, Quentin Brogdon testifying for myself against the bill. I've been a trial attorney for 33 years. And fortunately, during almost all of those 33 years, I've handled in one form or another sexual assault cases. I started out as a prosecutor in Houston, where I handled cases involving rapes, among other serious criminal cases. And then for a number of years, I was a defense attorney, during which I defended mainly premises owners, but also sliding glass door manufacturers and window manufacturers in cases involving violent rapes and assaults, usually almost exclusively of women. And so I've had, unfortunately, the experience of handling these cases for a number of years. Beginning in 1998, I moved to Dallas, and I became a plaintiff's attorney from that point on, but I've continued to handle those cases, including cases against rideshare companies, Uber, Lyft, and others. I'll tell you, beginning about 8 years ago, I started receiving a good number of calls from passengers in Ubers and Lyfts who had been sexually assaulted. Enough of those calls, and I've now handled probably 24 of those cases, enough of those calls that I began asking myself why. I had never gotten calls from people who rode in taxi cabs. I still haven't gotten those calls in anything like these numbers. Something is very broken. And so I began looking into it, and as Representative Davis said, the answer is pretty simple. It's fingerprinting. These companies don't do it. They refuse to do it. I understand they have a publicly stated position as to why they won't do it, but that's the issue. They're not doing proper screening of their drivers, and predictably, obviously, and preventably, those drivers are ending up paired with young, sometimes intoxicated, admittedly, but they market for those passengers, by the way, in those cabs, in those Ubers and Lyfts late at night, where they're basically locked in a car with these people. So the cases against these so-called transportation network companies, TNCs, are already hard because of the bill you all passed in 2017, HB 100. And it gave them quite a few protections that nobody else gets. It prohibits, actually, cities like Dallas and Austin and others from requiring fingerprinting. They only get to require the cities what's in that bill, HB 100, and fingerprinting ain't in there. So they don't get to require that. And then they only have to exercise ordinary care instead of the care that a taxi cab would have to exercise, or a bus driver, which is high degree of care because they're a common carrier. That's been rewritten in the law. So they already have quite a few protections already in the existing state of the law. But I just want to close with talking about some of the statistics, because unfortunately I've had the extremely unpleasant experience of sitting across the table from many, many rape victims. It is the worst nightmare for any woman. It's the worst nightmare for any man with a husband, a mother, a wife, a daughter, heaven forbid, as you just heard from Mr. Toller. So the statistics are pretty sobering. It turns out 2/3 of sexual assaults aren't even reported. So what we know about is the tip of the iceberg. And we wouldn't know what we know about unless it began. CNN in 2018 kind of pulled back the covers on the rideshare industry and the statistics, and I won't get into all that, but they did a comprehensive search. There were 103 Uber drivers accused of sexual assaults in the past 4 years, 18 Lyft drivers. And Uber and Lyft try and put those in a context of, well, look how many rides we do. But if you're the poor unfortunate victim, or if your daughter is, or your wife, of a sexual assault that was preventable, and I just don't see these numbers happening with taxi drivers. In the wake of that, Uber and Lyft have both released now reports of sexual assaults that shed some light on it. And I won't get into all the stats, but stats are pretty sobering. In October 21, Lyft had 4,100 total reports of sexual assaults in October 21. They released it between 2017 and 2019. They had 1,800 reports of sexual assaults just in the year 2019. Uber, likewise, has reported assaults in 2018. 1,560 reports of non-consensual touching of a sexual body part, 376 reports of kissing sexual body parts, 280 reports of attempted non-consensual sexual penetration, and 235 reports of non-consensual sexual penetration. So all of these statistics are sobering, and I'm simply here to say, please keep this in a context, and I understand the pitch has been made, this is traffic accidents and this, but my focus is more on these sexual assault cases, which unfortunately I've had the misexperience, some would say, of handling from both sides. I've defended them, I've prosecuted them, I've never defended a rapist. I've defended companies sued because of them, and I urge you to tread very carefully before you grant Uber, Lyft, and any other transportation network company further protections that would further disincentivize them to do what they should be doing, firstly fingerprinting, but other things as well, to make their passengers safe with the drivers they pair them with. Thank you very much for your time, and I'm here to answer any questions.
Your testimony. Let me go with Representative Flores and then Vice Chair Johnson. Representative.
Thank you for your testimony, and thank you for bringing up the fact that Austin and Dallas got preempted by the legislation, as we had a big fight, as you know, with the rideshare companies about fingerprinting and wanting to bring them up to the same standards that the taxi companies were held to. So I appreciate that, because I too think that the law that was written to not only preempt these cities from regulating their own cities and their own citizen safety, were greatly influenced, let's just say, by those companies in terms of writing in protections already there. So I do appreciate your testimony, and I just wanted to say that. Thank you.
Thank you, Representative Flores.
Vice Chair Johnson.
Hi, Quentin. This bill is aimed at filing frivolous pleadings, but we already have a statute in the Civil Practice Remedies Code, Chapter 10, of lawyers signing and filing frivolous pleadings and motions. We already have sanctions provisions in the statutes that judges can assess against lawyers for filing frivolous pleadings. So this remedy is already available to companies like Uber when they feel like that suits have been brought maliciously, correct? Or inappropriately. Is that true?
Agreed, 1,000%, Representative Johnson.
And
Vice Chair Johnson.
I know, doesn't that sound good?
I will give you your due title.
But I'm very concerned, as I've obviously expressed tonight, about the affidavit requirements for lawyers. Are you familiar with any scenario where a lawyer has to sign a personal affidavit sworn to by personal knowledge of the facts of the underlying case of the clients that they represent?
No scenario, and I believe it's not workable for the reasons you've said. It just encourages people to sign things potentially that get them in trouble for perjury later. Even the protection afforded doctors in the state of Texas, and I've handled a great number of medical malpractice cases over the years, does not require anything of this magnitude and putting the attorney in such personal jeopardy. I think it's redundant, it's not necessary, and I think the existing mechanisms in the law are there to be enforced for so-called frivolous cases.
Thank you.
Members, any other questions? All right, thank you for your testimony.